3%. If the vehicle was not running because of the fuel pump, which they gave the original diagnosis, if it's not running after they fix it, then
I'm trying to figure out how in a mile you figured that out.
because because when I brought it in, it was running. I drove it in there when I brought it.
No. What I'm trying to figure out is, let's say it was running. Let's say everything is as you say it is. When you leave their facility, how do you know the vehicle isn't running?
When we left the facility, it was running. I drove it.
You drove it away from there.
I drove it away.
Okay, so then how, folks?
But it was also running when
it was performing the same way when we brought it in there originally. It was performing.
It's just that what the problem was that it was stalling out, and it.
Okay, so how do I know in that mile?
This is where you can already feel the judge pumping the brakes. She's not being hostile. She's doing something worse for this case, asking logical questions that don't have clean answers. The timeline matters in court, and right here, it's already getting messy.
Because we rendered their services to fix the pump in the first place.
But you then don't bring it back until 2 years later. There is no workplace anywhere that is going to give you a warranty on a part, particularly a 1999, that I'm talking putting a part on a 10-year-old vehicle, that I'm going to warranty that part for over 2 years, because that's what you're asking them to do.
This part might sound boring to people, but this is the law talking. Courts don't run on vibes or frustration. They run on responsibility. A 10-year-old vehicle, a repair from years ago, and now a demand that someone be held accountable indefinitely? That's not how civil liability works.
June 9th of 2020 and October 3rd of 2022, I have no idea what happened with that vehicle. None. And even you guys don't have any idea, at least for 3 months.
For 3 days. We know it didn't start 3 days later.
3 months. July 2nd, 2022 to October 3rd, 2022. You guys have no idea what happened with that vehicle because it's not in your possession. Go ahead.
We have their diagnosis.
You want to know what? Let's have, okay, when do we want to try this? Because this is going to be I'm just telling you.
Okay, well, let's take it to trial. Whatever. Let's do what we got to do.
No, don't tell me, okay, let's take it to trial. Do not play with me like that.
Yes, sir.
Good answer. I'm just telling you right now, you've got significant proof problems. Because, can you get that wrong? Because you got 2 years. You're saying they didn't put on the part. Who's going to tell me that that's the original one that's put on? This guy's going to say it looks like the original one. Right? He would have given you a part that, quite frankly, I could go to any junkyard. They got a 1990 Jimmy, I can probably get that part. And somehow or another, you're going to say they bought a part, didn't put it on, and now you're trying to hold them accountable 2+ years after the fact.
This is the heart of the problem. 2 years. 2 full years where no one can say who touched the car, who drove it, or what changed. In court, silence isn't neutral. Silence destroys credibility. And the judge is basically saying, you're asking me to guess. Judges don't guess.
I mean, folks, just hear me out. It's one thing, you take it in there on June 9, 2020, and let's say you get it to somebody July, let's say 1 month after the fact, right? And you get it to some place and they say, this part hasn't been replaced. Here it is. That could be a compelling case if they didn't put it on. But what you're asking now is that and by the way, that it was doing the same thing, right? Right after the repair. Here, you can correct whatever you think is different about the story, is 2 years plus, really 25 months. After they supposedly have the part, I take it back saying it doesn't work. Or that what happened didn't work. I don't even know how you're going to begin to show that to me. I really don't.
This moment hurts, honestly. You can hear the frustration from the plaintiff, but frustration isn't evidence. When a judge says, I don't even know how you'd show that, that's not sarcasm. That's the court telling you the case has no foundation.
No. Because, hold on a second. At the time, you don't know that the part is faulty, do you?
No, I do not.
So if you don't know that it's a faulty part, how's he trying to rectify the faulty part?
Maybe because they've already done a diagnosis and they see it's the fuel pump. This was after the diagnosis, the second diagnosis. And he agreed, yeah, we'll take care of it.
Okay. We'll take care of it. So what's that mean? I've got a customer that wants something done. We'll take care of it. Yeah.
I'm curious, he's the mechanic, how long is the fuel pump supposed to last in the vehicle?
Well, man, that's going to depend. I mean, I know enough about fuel pumps. I mean, you can put one in and it's operating just fine, but there are other parts of the system that are relying upon that fuel pump. And so, I mean, you can get a defective fuel pump.
Mm-hmm.
I mean, that can happen. But I can't even say that's what happened in this case.
But the evidence from the other shop, he states that the components, he can clearly see that the components for that fuel pump were not touched. He said once those straps come off, they're broken. They need to be replaced. These are still.
How do I know that didn't happen?
Because he said so. He's the mechanic.
No, ma'am.
We didn't drive. Because listen, if we didn't drive the vehicle, then everything's still going to be new. Why would it be used if it's not being used?
Ma'am, that's part of the proof problems, isn't it? I mean, that's what I'm saying.
This is where technical language actually backfires. Once mechanics disagree, the burden gets heavier, not lighter. The judge keeps coming back to one thing: proof. Who can prove what and when? Without that, even a sympathetic story collapses.
Case sits right now.
Okay.
Don't interrupt me. We're going to have a way to you know what? Tell you something, Mr. Montgomery. No, you'll hear me. I'm going to tell you right now. I expect people to conduct themselves in certain ways in my courtroom. I don't know. Just listen to me. I don't want this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever, you can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something what comes out of your mouth, because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
Yes, Your Honor.
And then we end here. Respect. Courts will tolerate confusion, emotion, even weak cases. What they won't tolerate is disrespect. This wasn't a threat for drama. This was a reminder that the courtroom isn't social media. It's an institution. And once a judge has to say this out loud, you already know how the case feels from the bench.